This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Will kindly come to the preamble, because this preamble has been noticed, discussed, and applied by the Supreme Court number of occasions, but it is my privilege and I have the pleasure to bring it to your lordship notes too. Now, state to him, Lord, kindly come to: we, the people of India, having solemnly resolved to constitute India. Therefore, India is being constituted on that day. For what purpose? Forget about not the democratic so and so. Justice, social, economic, and political. And then most important part is fraternity, assuring the dignity of the individual. That is a very important part which was incorporated by Mr. Ambedkar while he was concluding the draft with regard to the preamble. Why individual dignity? That in our country we have seen that the individual, for many reasons.
You can take your seat. You have a chair behind
Take
you.
a seat. Yes, that's
Otherwise, you can take your seat.
it will. Sir.
Only one thing, Mr. Bhattacharya, I request through you to your clients, because the advocates are not finding place to stand. Can you request your clients to please?
I am told my clients are not in the courtroom.
Otherwise,
client also.
if the advocates are do not find place to stand to make argument, it will be difficult. The Deputy Solicitor General is also not
Right,
finding
Jara.
space to come in.
Advocate.
Yes.
ভাই প্লিজ একটু ধৈর্য ধরুন, সাইলেন্স মেইনটেইন করুন, আমিও কনসেন্ট্রেট করতে পারছি না। প্লিজ। Article 21, Lord, protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. And the Supreme Court has subsequently said law means fair and justiciable. Now, in this background, Lord, I will just invite my lord's kind attention, my lord. The consideration by the Supreme Court long back in 80s. '84 volume 3 Supreme Court cases. Yes.
84-3 SCC.
Learned 3 judges of the Honorable Supreme Court while considering page 161.
Sir, 1984-3.
Yes.
My lord, will kindly come to paragraph 10.
161.
Yes.
Moreover, when a complaint is made on behalf of workmen that they are held in bondage and are working and living in miserable conditions, now I'm emphasizing on this. Living in miserable conditions without any proper or adequate shelter over their heads, without any protection against sun and rain, without 2 square meals per day and with 1 dirty water from Nala to drink, it is difficult to appreciate how such a complaint can be thrown out on the ground that it is not a violative of fundamental right of the workman. It is the fundamental right of every in this country. I repeat, it is the fundamental right of everyone in this country, assured under the interpretation given by Article 21 by this court in Francis Moline's case, to live with human dignity, free from exploitation. This right to live with human dignity enshrined in Article 21 derives its life breath from the directive principles of state policy, and particularly clauses E and F of Article 39 and Articles 41 and 42, and at the least, therefore, it must include protection of the health, strength of workers, men and women, and of the tenderage of children against abuse of work, against abuse, opportunities and facilities for children to develop in a healthy manner and in conditions of freedom and dignity, educational facilities, just and humane conditions of work and maternity relief. These are the minimum requirements which must exist in order to enable a person to live with human dignity. And no state, neither the central government nor any state government, has the right to take any action, can you underline this, any action which will deprive a person of the enjoyment of these basic essentials. Since the directive principles of state policy contained in clause E and F of Article 39, Article 41 and 42 are not enforceable in a court of law, it may not be possible to compel the state through the judicial process to make provisions by statutory enactment or executive fiat for ensuring these basic essentials which go to make up a life of human dignity. But where legislation is already enacted by the state, providing these basic requirements to the workmen and thus investing their right to live with basic human dignity with concrete reality and content, the state can certainly be obliged to ensure observance of such legislation for inaction on the part of the state in securing implementation of such legislation would amount to denial of the right to live with human dignity enshrined in Article 21, more so in the context of Article 256, which provides that the executive power of every state shall be so exercised as to ensure compliance with the laws made by Parliament and any existing laws which apply in that state. We have already pointed out in Asia's construction work that the state is under the constitutional obligation to see that there is no violation of the fundamental right of any person. Sorry, see that there is no violation of the fundamental right of any person, particularly when it belongs to the weaker section of the community, underline this, and is unable to wage a legal battle against a strong and powerful opponent who is exploiting him. The central government is therefore bound to ensure observance of various social welfare and labor laws enacted by Parliament for the purpose of ensuring to the workman a life of basic human dignity in compliance with the directive principles of state policy. It must also follow as a necessary corollary that the state of Haryana, but I am not going to that, that is with regard
That was on the facts of that case.
Therefore, they fundamentally now, as far back as 1980s, the Supreme Court finds what is the scope of really Article 21. Now kindly come to another judgment delivered by Honorable Justice Shobbaschi Mukherjee, as his lordship then was, 89, corresponding to কত জন বলেছিল না বই বার করো
পিছনে আছে
Bhaiya, 1989 SC page
549.
আমার কাছে আছে
Look, this corresponding to 1989 supplementary, I am just handing over a copy to your lordship. 1989 supplementary 1 Supreme Court cases, page 251.
Wait, sir, kindly.
But this is really with scope of Article 32. I am not really troubling my lord with that. That will be.
you don't want to rely upon
No, no. That really deals with basically the scope of Article 32. Therefore, I am not really troubling my lord with that now. Now, my lord, kindly come to the latest view of the Supreme Court on Article 21 and also how the Constitution has to be interpreted. First, kindly come to 2020 10 Supreme Court cases, page 459.
2020, sir.
459. This is on what issue?
বসার জায়গা নেই।
The scope of Article 21.
এই তুমি বসো আমরা
Just any problem, Mr. Trivedi?
No, 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 no.
I was
I am.
asking the chair.
Yeah.
There is no, there is no.
No.
I am giving you that chair. I am giving you that chair.
I'm used to be a standing.
No. It
You have.
Now, my lord, this was, my lord, in the background when there was a COVID. Now, the Gujarat government wanted to, my lord, ask the employees to work overtime without any limitations. And in that background, my lord, these issues came up before the Supreme Court. And Supreme Court, my lord, decides the matter. Kindly turn to, my lord, paragraph 44.
Yes.
The constitutional vision of social and economic democracy. এই তোমরা বসো না, দাঁড়িয়ে থাকতে অস্বস্তি হয়। Recognize the transfer of power, but the constitutional vision of Swarajya transcends the devolution of political power. The fundamental rights and directive principles of state policy present a coherent vision of a welfare state that envisages justice, social, economic, and political. Grenville Austin, in his seminal work on the Indian Constitution, has collectively described them as the conscience of the Constitution, which connects India's future, present, and past by giving strength to the pursuit of social revolution in India. The colonial experience and the poverty it sanctified as an incident of state policy were the driving force in the Constituent Assembly's goal to achieve economic equality and independence. Although the directive principles were not intended to be capable of being independently enforced before the courts to invalidate a legislation, they inform state policies, act as a guidepost for the legislation, and provide signposts for travelers engaged on the path of understanding the complexities which the Constitution unravels. Eminent legal scholar Upendra Bakshi, while reviewing Grenville Austin's work on the Indian Constitution, had analyzed the dichotomy of justiciability and non-justiciability of fundamental rights and directive principles. He had noted, quote, in no other area of constitutional scholarship, the need to ascend from the planet of platitudes to an analytical paradise is more compelling than in the study of the directive principles. The fact that this is distinction in justiciability is now a constitutional reality should not be allowed to obscure the more important fact that the directive principles and fundamental rights are both originally rooted in a vision of a new India. And though many writers on constitutional law have been led to draw a radical and sharp distinction between rights and principle, it is heartening that judicial decisions making has not failed to maintain the awareness of their basic unity. Therefore, always, my lord, the court has gone into the basic purpose and the responsibility of state under the Constitution. Then kindly, my lord, come to 2020.
Unity between these rights and the directive principles.
My lord,
Unity between the fundamental rights,
rights and directive. One is, my lord, really depending on that. The two-legged, my lord, force. You cannot simply say directive principle is not enforceable, therefore I will ignore that. That's the basic interpretation, my lord, which has been developed from time to time by the constitutional interpreters. So the Supreme Court says we are the interpreter of Constitution, not the government. Now, my lord, kindly come to 2024, 15 SCC. The very latest, my lord. আমার বইটা আমাকে দাও।
page
2024, page 535.
535.
Yes. But I would take my lord's kind leave to place it little extensively. Kindly come to paragraph 6 and 7, then I shall proceed. Paragraph 5, this is under the heading of constitutional interpretation. As we deal with the present petition, we must refer to the values of the Constitution and the interpretation we must adopt. After all impugned provisions of the various prison manuals highlighted in this petition demonstrate that the values of the Constitution are at stake. Therefore, mere legislation, my lord, is no escape. Then, the Constitution reflects the vision of its founders to give India a collective future based on the values of liberty, equality, and fraternity. The Constitution mandates a more just and inclusive society where every citizen has the opportunity to thrive. It envisages that the values embedded in its provisions are not just aspirations, but lived realities. Any interpretation of the Constitution must be reflective of the blueprint laid down by its founders. The Constitution is, as Granville Austin put it, quote, a social document and modernizing force with provisions embodying humanitarian sentiments. Then, the interpretation of the Constitution is not static. But I will try to invite your lordship's attention to this. The Constitution, according to my understanding and understanding of all, is a dynamic document. The interpretation is called for the change of society and social situation. It cannot be anything which is bereft of the social condition. That's why I say the interpretation of the Constitution is not static. It has evolved with time to give recognition to a broader spectrum of rights to the citizens, as well as to impose additional safeguards against excesses of the state or even private entities. I relate it to the individual dignity. I have power, therefore I will throw you out like anything. No, that is not the Constitution. I repeat, my lord, it has evolved with time to give recognition to a broader spectrum of rights to the citizen, as well as to impose additional safeguards against excesses of the state or even private entities, as the case may be. Over the last 75 years, the Supreme Court has recognized new rights, such as the right to education, right to privacy, and the right against the adverse impact of climate change, among others. These rights, though not explicitly mentioned in the original text, have been interpreted as inherent in the broader principle of the right to life, which the Constitution enshrines. Here we are involved with the principles and concept of right to life. Just to give you a lot with the reference to the facts, we are the hawkers. We are the slum dwellers. Now, we are forced to carry on that profession and live in slums, which is part of my right to life under Article 21. State's duty is to make it better, not to make it worse. Not to throw me out. If you throw me out, you also ensure my living. Right to life has a meaningful explanation. That's why the Supreme Court says. These rights, though not explicitly mentioned in the original text, have been interpreted as inherent in the broader principle of the right to life, which the Constitution enshrines. But why I say this, the Supreme Court refers that though there may not be any statute, but even then, your action as an executive has to be in conformity with the principles and the essence of Article 21. The Constitution must serve as a robust framework for safeguarding the rights of the citizens and maintaining the delicate balance between the authority and individual freedom. Where the question comes that if you want to do something, do it in such a manner that the individual freedom is not destroyed. Then the Constitution recognizes the dignity and individual autonomy inherent in all citizens and their right to life and personal liberty. Liberty and autonomy advance the cause of human dignity. Individual autonomy is the ability to make decisions on matters that impact one's life. But why this is mentioned? I am today not hawking because of my own desire. That's why the Supreme Court says, when the individual's ability to make decisions on matters that impact one's life. When individuals are granted the freedom to make choices about their own lives, they are empowered to take control of their destinies and express their identities in the pursuit of happiness without undue interference. This freedom fosters a sense of self worth and respect, thereby recognizing individual dignity. By safeguarding these principles, we ensure that intrinsic worth of every human being is recognized and upheld. The right to life cannot be restricted except through a law which is but is important. Except through a law which is substantively and procedurally fair, just, and reasonable. Mere saying that I have been empowered by statute would not do.
So according to you, this is the restrictions which can be imposed on that
Yes.
right to life.
That right, you have to honor the right to life. But if you want to do something,
Reasonable restrictions can be put in,
yes.
but how?
How?
That is
That. Then again, Lord, kindly come to next also. Paragraph. There's an interesting Lord, interpretation of Constitution has come. Very interesting. Our interpretation of the Constitution must fill the silences in its text. As you say, Lord, we have to go not by the letter but by the spirit as well.
if there is any ambiguity.
Even if there's an ambiguity, if the court finds that this really is not sufficient to protect and spread the concept of Article 21, court will interfere. That's the, Milord, the tendency. I read once again, Milord. Our interpretation of the Constitution must fill the silences in its text. Silence would mean it's not there. The framework
The alternative, the gaps.
gaps. Ordinarily, in case of statute, we say causes omissus, but that has to be gone into, Supreme Court says. The framers of the Constitution could not have anticipated every situation that might arise in the future. They also intentionally left certain decisions to the discretion of future generations. However, the choices we make today must align with the broader constitutional framework and values. You cannot simply throw a person and force him to live under the sun and eat grass. You cannot say that. In filling the gaps whenever they arise, Milord, this I appeal to your lordship, Milord, this really calls for your lordship's own interpretation. In filling the gaps whenever they arise, our interpretation must enhance the foundational values of the Constitution, such as equality, dignity, liberty, federalism, and institutional accountability. Our interpretation must adhere to the postulate that civil and political rights and socio-economic rights do not exist in a state of antagonism. Don't think that they are our enemy. You have to do this in the light, in the socio-economic rights do not exist in antagonism. Our analysis must be based on a holistic reading of the provisions of the Constitution. But again, it's up to your lordship's determination. You have to take a holistic view. The Constitution mandates, paragraph 11, that laws enacted in the colonial era should align with its provisions. Constitutional interpretation emphasizes the need to reverse the philosophy of the colonial regime, which was founded on the subordination of the individual to the state. Now we are going back to the colonial concept. The assumptions which lay at the foundation of colonial rule have undergone a fundamental transformation for a nation of individuals governed by the Constitution. By recognizing the injustices in the colonial and pre-colonial era, we can certainly set the course of the future. The transformation of society against colonial and pre-colonial ideology, the Constitution seeks to assure the values of a just, humane, and compassionate existence to all her citizens. Then, my lord, I will invite my lord, where Article 21 is specifically dealt with. Yes. Well, this is paragraph 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. 69. But in earlier paragraphs, Lordship will see, my lord, they have been discussing, my lord, the Constituent Assembly debate and others. No,
Article 2169, paragraph 69 onwards.
now, my lord, before that, I missed it, my lord. My juniors pointed out. My lord, the paragraph 14. The Constitution of Emancipation, Equality and Dignity, under this heading, Supreme Court is discussing. May I proceed, my lord? Paragraph 14.
Yes.
The Constitution of India is an emancipatory document. Well, I don't have to explain, Lord, the meaning of emancipation. Emancipatory document means it leads us to the more areas of freedom. It provides equal citizenship to all citizens of India. The Constitution is not just a legal document, but in India's social structure, it is a quantum leap. In one stroke, it gave a dignified identity to all citizens of India. On 26th of January 1950, the Constitution eliminated the legality of caste based. I am not troubling Lord on that. Then kindly come to another paragraph 69. Article 21 provides that no person shall be deprived. No person shall be deprived of his life or personal liberty except according to the procedure established by law. In number of judgments, the court has expanded the meaning of life. It has been held that the right to life enshrined in Article 21 cannot be restricted to mere animal existence and means something much more than just physical survival. It includes the right to live with dignity, not live on begging. This is no dignity. Live on your own labor. That is dignity. In fact, dignity forms a part of the basic structure of the Constitution. The references to dignity are found in the guarantee against arbitrariness, the lamps of freedom, and in the right to life and personal liberty. Thus, dignity is the core which unites the fundamental rights, because the fundamental rights seek to achieve for each individual the dignity of existence. My existence is at stake. My Lord saved us, my Lord, by passing an interim order. Therefore, this, again I say, my Lord, the Supreme Court is repeatedly saying that what would the real meaning of Constitution would be. Thus, dignity is the core which unites the fundamental rights, because the fundamental rights seek to achieve for each individual the dignity of existence. In that sense, human dignity is a constitutional value and constitutional goal. That what more could the Supreme Court interpret? When it says the human dignity becomes a part of constitutional goal. The court has authoritatively ruled to live is to live with dignity. Human dignity is intrinsic to and inseparable from the human existence. Therefore, human living means with human dignity. Implicit in this right under Article 21 is the right to protection against torture or cruel, inhuman or degrading treatment. But we are facing cruel treatment. Suddenly bulldozer comes, demolishes everything. But for order of this court, few people could survive. In spite of the passing of the court, they have carried the operation saying that this matter is not before the court. Would that be the view of a democratic constitutionally formed government? When a similar matter, court has considered prima facie pass certain orders. Stay your hands. No. And every day, every night, my lord, the mass of people are facing this cruelty and torture. If your lordship, I don't think your lordship will have the advantage of looking these realities, but I have. We had to go, face, fight, argue. I have mighty force, central forces, state forces, push them out, throw all these people. A little girl is weeping that my school books is gone. I can't go to school tomorrow. They do not think this is a part of human dignity, but we feel, and that's why before your lordship. The dignity of paragraph 7, the dignity under Article 21 is an integral aspect of life, which requires sustenance of one's being to the fullest. One can truly embrace their identity, whether on the basis of caste, race, gender, sexual orientation, or ethnicity, only if they are given dignity. An individual's dignity is a fundamental to their sense of self and autonomy. Thus, the right to dignity encapsulates the right of every individual to be treated as a self-governing entity having intrinsic value. Above all, there is a growing recognition that the true measure of development of a nation is not economic growth, it's human dignity. A nation must prioritize human dignity, ensuring that every person, regardless of their background or identity, is able to live with respect, equality, and freedom. Thus, human dignity forms the bedrock of social justice and a just, compassionate society. The next paragraph, the right to live with dignity extends even to the incarcerated. Now today we are not facing somebody is accused of very grievous crime. He's being paraded, organized to throw eggs. Tomorrow it might be organized to throw stones. What are you going to? The right to live with dignity extends even to the incarcerated. Not providing dignity to prisoners is a relic of the colonizers and pre-colonial mechanisms, where oppressive systems were designed to dehumanize and degrade those under the control of the state. Authoritarian regimes of the pre-constitutional era saw prisons not only as places of confinement, but as tools of domination. This court, focusing on the changed legal framework brought out by the Constitution, has recognized that even prisoners are entitled to the right to dignity. But I am placing only to show that dignity, human dignity, is such an important and superior pedal that whatever I do under that, not go beyond that. Then the rest portion that I am not placing, because all these judgments will not, which were delivered by the Supreme Court.
Prisoners' rights and other things.
Now, my lord, now if your lordship kindly fall back to paragraph 17.
Mr. Ahmed is not allowing you to proceed further. He's taking you.
So that's good, they have studied. It's good, my lord, that they have studied.
Yes.
The Constitution mandates the replacement of fundamental wrongs with fundamental rights.
Yes.
Through its provisions, it displaced a centuries-old caste-based hierarchical social order that did not recognize the principle of individual equality. It negated the ideals of social hierarchy. The Constitution is the embodiment of the aspirations of the millions of caste oppressed communities that have already replaced medicine. Then your lordship can come. But on the issue, if two fundamental rights are in conflict with each other, what would the court do? This is 2017 4 SCC.
How two fundamental rights are in conflict?
Well, they might come say that a pedestrian has a fundamental right to use. Not a pedestrian has a right to have the free access to the
Pavements.
pavements.
and some occupying the pavements and
There was
installing
a conflict of two fundamental rights. Now, what would be the view of the court? Now, this is 2017 for SCC, page 397. We kindly come to the paragraph 54 onwards.
Yes.
Paragraph 54. Having noted thus, as presently advised, we shall first advert to certain authorities that pertain to balancing of rights. In Shokal papers, the court, in the context of freedom of speech and expression, has held that freedom of speech can be restricted only in the interest of the security of the state, friendly relations with the foreign state, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. It cannot, like freedom to carry on business, but curtailed in the interest of the general public. Analyzing further, the court held, quote, it follows from this that the state cannot make a law which directly restricts one freedom, even for securing the better enjoyment of another freedom. All the greater reason, therefore, for holding that the state cannot directly restrict one freedom by placing in otherwise permissible restriction another freedom. Well, keeping in this mind, don't not take it otherwise. This is my personal experience in a different capacity. We had ensured that the pavement 2/3 should remain free for the pedestrians. And you can have your business, which is more fundamental, only within the limit of 1/3 of the area, but you can't block the entire thing. And that was being followed for quite some time. Following this principle, then not in 55, Subramaniam Swamy is quoted. I am not troubling my lord with that. Then kindly come to my lord. Paragraph 56. In this context, it is also appropriate to refer to certain other decisions where the court has dealt with the concept of competing rights. We are disposed to think that dictum laid therein has to be appositely appreciated. In X versus Hospital, the issue arose with regard to right to privacy as implicit in the right to life and liberty as guaranteed to the citizens under Article 21 of the Constitution, and the right of another to lead a healthy life. Dealing with this said controversy, the court held that as a human being, Miss Y must also enjoy, as she obviously is entitled to, all the human rights available to any other human being. This is apart from and in addition to the fundamental right available to her under Article 21, which guarantees right to life to every citizen of this country. The court further held that where there is a clash of two fundamental rights, namely the appellant's right to privacy as a part of right to life, and Mrs. Y's right to lead a healthy life, which is her fundamental right under Article 21, the right which would advance the public morality or public interest would alone be enforced to the process of court, for the reason that moral considerations cannot be kept at bay, and the judges are not expected to sit as mute structures of clay in the hall known as the courtroom, but have to be sensitive. Here you come with two competing, which is more important vis-a-vis the earlier, the Supreme Court judgments. The core of the Constitution, the heart of the Constitution is human dignity. And human dignity means not just biological living
or physical existence.
And then kindly, next paragraph is very important. paragraph 64.
64.
64. বিপরীত। না, কতগুলো পড়ার দরকার নেই। While appreciating the concept of public interest in such a situation, the court is required to engage itself in construing the process of fair trial, which ultimately subserves the cause of justice and remains closer to constitutional sensibility. An accused in the name of a fair trial cannot go on seeking adjournments defeating the basic purpose behind the conducting of a trial, as enshrined under section 309 of CRPC. He cannot go on filing applications under various provisions of the CRPC, whether tenable or not, and put forth a plea on which every occasion of the bedrock that principle of fair trial sanctions. In such a situation, as has been held by this court, the prosecution which represents the cause of collective and victim who fights for remedy of his individual grievance is allowed to have a say, and the court is not expected to be a silent spectator. Thus, the discord that arises when there is an intra-conflict in the same fundamental rights, especially in the context of fair trial, it has to be resolved regard being had to the obtaining fact situation. It cannot be with a straitjacket formula. An accused who has been able to, by his sheer presence, erode the idea of safety of a witness in court, or for that matter, impairs and rusts the faith of a victim in the ultimate justice, and such erosion is due to fear psychosis prevalent in the atmosphere of trial, is not to be countenanced, as it is unconscionable situation. Such a hazard is not to be silently suffered, because the majesty of justice does not allow such kinds of complaints to survive. Thus, analyze the submissions of so-and-so and shifting of the accused outside so-and-so would affect his right under Article 21, does not comment acceptation. Then an individual accused. Because right to fair trial gives the foundation to the social justice. Just a minute. When my lord, I do not just repetition of my lord same. I am not traveling my lord with that. Therefore, the basic concept is that when two conflicting fundamental rights comes before the court, the duty of the court to ensure which is greater justice.
Public interest.
Larger public interest. And here, the competing interest is according to the railways that you are occupying the platforms. Since when? One important query came from the court, they couldn't answer. But now I lead your lordship, try to submit to your lordship, the doctrine of destitute comes into operation. You have power, you do not exercise the power. Allow something to continue, then it is to be deemed that you have no power to exercise. Lord, I just first elaborate on craze on statute law. I will read and hand over to your lordship, following which the Supreme Court of our country that has followed the principle. Even our High Court has followed, same. But since this book is very rare,
Yes.
I just read out and hand up to your lordship.
Can you give me
It
a
was
photocopy of that?
I shall. Craze on statute law. এই এটা ফটোকপি করে দেওয়ার সাথে I'm just now reading the relevant portion and handing up to your lordship. Can you excuse me, my lord, this was underlined for my purpose.
That will help me. Please give a copy with those underlining.
Yes, I shall. Lord Mackay usefully described the nature of destitute in Brown versus Magistrates of Edinburgh, when he said, quote, I hold it clear in law that destitute requires for its operation a very considerable period, not merely of neglect, but of contrary use of such a character as practically to infer such completely established habit of the community as to set up a counter law or establish quasi-repeal. Because if the hawkers are there, within 7-10 days, you remove them. You allow them to continue for 30 years, it becomes part of their livelihood. And now we come, I should remove it because I have the power. Whether you can do that. Milord,
Give me a photocopy of that.
copy. Now, Milord, our Supreme Court has also, Milord, followed this.
Take a Xerox copy, Mr. Bhattacharya, because if
I
that-
shall give the
because otherwise that book will get damaged.
Xerox copy.
Get that pressure while making that photocopy,
Well, হবে না।
book gets damaged, take a photo impression and then.
হ্যাঁ, এটা পাশাপাশি তোমাকে এটাও দিতে হবে, এটাও দিতে হবে। পাবলিকেশন
The edition also. Yes.
সুপ্রিম কোর্ট হ্যাঁ 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 কোথায় কোথায় বারবার এটা আনতে বলেছি আমি।
হ্যাঁ।
ওইটা
Don't hear it.
ফোন করেছেন।
Yes, yes.
আসেনি?
ওই পাতাটা ছবি দিয়ে পাঠিয়ে দাও।
Make a legible copy. That's
রিপিটেডলি বললাম যে আসবেন কেউ নিয়ে আসবে। কোথা দেবে কেন তো
yes, what? Don't have a copy?
হার্ড কপি করোনি?
Just give me the
তো
citation.
এক কথা বলতে বলতে আমি তো ক্লান্ত হয়ে যাই তোমাদের এই কাজ করতে করতে। হ্যাঁ আছে তোমার কাছে? সফট কপি কি হবে? 10 তো দেওয়া আছে ওটা।
Yes. Which paragraph?
মিলট
Mr. Ahmed, please give me a photocopy.
Ah.
Yes, paragraph.
kindly come to Milord. I just proceed Milord from paragraph 29.
29.
Yes. 29 is not the 11th paragraph, but to get the background of it. Or rather from 28. What has been stated relating to executive construction or practical construction in Crawford's interpretation of laws, to which has been relied on by learned Advocate General, would not persuade us to agree with him in his submission, though it may be permissible to take note of post-enactment history to find out as to how an enactment was understood on the principle of contemporaneous exposito, or which mention have been made at so and so, so and so. The learned Advocate General is not relying on the statements made in the aforesaid government order for the purpose of the interpreting of two notifications, but for contending that the notification had stood effaced because of what has been stated therein. On the principle of contemporary exposito, my lord, I just skip over. Then kindly come to the paragraph 30. Learned Advocate General's another submission relating to implied repeal is that 1918 notification, having not been acted upon, must have taken to have become a dead letter because of its long disuse, and the same stood repealed because of the legal process known as destitute. He draws our attention to what has been stated in this regard in Francis Benon's statutory
Why are
interpretation,
you citing this decision? For what?
that if you do not exercise your authority,
So this is on statutes which have been repealed or which is.
no. We'll say it's implied repeal.
Yes.
I also cited my lord the case where said if you do not exercise power and allow something to continue for quite some time,
Yes.
then it is deemed that that act has become impliedly repealed. For that purpose,
Act means statute.
the statute,
Which statute?
which has empowered you to take action, and without,
That's according to you, the Railways Act, section
I say
147.
yes, 147 had empowered you, but you did not take action and allowed it to continue for more than 30 years. That means you have not exercised the power and you cannot use it now.
So according to you, since these persons are in occupation for a fairly long time, and you had the power to remove those trespass,
But
147 immediately thereafter, or and you allow them to continue for a pretty long time, then it must be hailed that you have you cannot now exercise the powers under that.
now, my lord, this is the principle, and Lord, which was also followed, my lord, by our High Court in a matter, my lord, where
Paragraph 30 you are referring. You want to refer any other paragraphs?
but that is the basic paragraph. my lord.
28 and 30.
Yes, yes. And my lord, also the paragraph. আমার বইটা আনো না কেন জানি না আমি। এই কিন্তু আমি সফট কপি আমি কমফোর্ট। Paragraph 60.
not in this.
6-0.
Oh, keep bolo. Now, my lord, the same principle was adopted, my lord, by our High Court, wherein, my lord, I had challenged the recognition of a police union that is reported in কি ফলো করছি দেখে বলো।
The 2012 SCC on
তোমাদের উপর রিলে করা যায় কবে থেকে বলবো দিন আজকে সেই আবার সেই সফট না দিস ইজ রিপোর্টেড ইন
Yes. What is the reference, Mr. Ahmed?
2012 SCC online
2012
SCC online CAL 12464.
12464.
It was also reported in 2013 1 CLT 652.
What is the cost title? 1 CLT High Court page.
652.
What is the cost title?
cost title is Bijit Mohan Mishra.
Vijay Chorao versus
Yeah, Vishwa Rao.
paragraph 60 statement.
Now, the background of this particular case was just Your Lordship,
Police
the
association.
police association had the recognition. In 2011, the new government came to power, and 2012 they have cancelled this. It was challenged. Now, the state took a plea that there is a law, by virtue of that law, he could not have formed the association. The court held the association was formed, you recognize them, and it continued for last almost 25-30 years. Now you cannot take this plea.
Since you have not exercised powers under that
At that time.
statute at that relevant point of time.
Now, my lord, this is the principle which was, my lord, accepted. Kindly straightway come to paragraph 16.
Yes.
In course of hearing, having regard to the undeniable facts that the recognition granted in favor of the three associations were accepted and allowed to continue uninterrupted till January 10, 2012.
Which paragraph?
60. You got it?
Yes, no. Yes, yes. I was thinking 16.
60. Were accepted and allowed to continue uninterrupted till January 10 to 12. It
Yes.
seemed to the court that the act had been allowed to grow in age by the state government in desuetude. Mr. Bandyopadhyay was called upon to advance argument as to why the act may not be held to have lost its efficacy by reason of the doctrine of desuetude. The only submission raised by him was that the court was making out a third case, not traceable in the pleadings. And in this case, in this connection, he placed reliance on several decisions. Reference to each one of them is not necessary, since law is well settled in this behalf. Then, here case statute law is quoted.
That has been quoted.
Yes. Then, again, my lord, in paragraph 62, the Supreme Court 1997, which I have placed before Lordship, is taken note of.
Yes.
But here the court also takes the other view in consideration in paragraph 63. This court is not oblivious of the legal position that in the early 80s of the past century, the Supreme Court in its decision reported in 82-3 SCC, so and so did not approve of repeal of the statute by the doctrine of desuetude and took a view that is different from the view taken on the decisions of more recent origin. It was ruled therein as follows. Quote, it is a matter of common knowledge that Parliament considered it necessary to reorganize the existing states in India and to provide for it other matters connected therewith, and with that end in view, the States Reorganization Act was enacted. As a result of reorganization, boundaries of various states changed. Some of the states merged into the other state in its entirety. while some states got split and certain parts thereof merged into one state and other parts rise to various complex problems. These problems are bound to arise from time to time. The Act is a permanent piece of legislation on the statute book. Section 14 of the General Clauses Act provides that whereby any central act or regulation any power is conferred, then unless a different intention appears, that power may be exercised from time to time as occasion arises. The section embodies a uniform rule of construction that the power may be exercised from time to time when occasion arises, unless a contrary intention appears, is therefore well settled. A statute can be abrogated only by express or implied repeal. It cannot fall into desuetude or become inoperative through obsolescence or by lapse of time. Now, this was the view, Mulot, of the earlier court, which was being discussed in detail. I'm not troubling my lord with that. Then kindly come to the paragraph 64.
64 last sentence.
Yes.
The statute remains as if it were repealed.
Yes. Therefore, Lord, these principles, sir, my lord, in my humble appeal, would have to be taken into consideration, my lord, when they are really creating such a situation to deprive the people of his right to life, shelter, and another judgment, my lord, in respect of Delhi Development Corporation 2011 4 is the same principle was adopted.
2011
4 SCC 180. But here the issue was very short, that after a long lapse of time, the Delhi Development Authority raised a huge bill, saying that this is the due you have to pay. The Honorable Court held, the bench was presided by Justice Altamas Kabir, and the other manager was Justice Joseph, that in course of time, you having allowed them to pay the taxes which was being paid, now suddenly you cannot rise and say you have to pay. Delay in exercising power makes the power void. Now, I'm just reading Miller, paragraph 21 and 22.
Paragraph 21, sir.
Yes. 21. Having considered the submissions made on behalf of DDA and the respondent appearing in person, also having considered the reasoning of the learned single judge and the division bench in repudiating the claim of misuse of charges by DDA, we are unable to convince ourselves that the decisions rendered by the High Court, both by the learned single judge as also division bench, require any interference in these proceedings. The materials on record will show that the respondent took prompt steps against the tenants for their transgression. During arguments, it was indicated that, in fact, one of the tenants had already vacated the portion of the premises occupied by him. It is also very clear that after using the show cause notice, the petitioner did not take any follow-up action thereupon. Instead, after a lapse of 25 years, the petitioner set up a claim on account of charges for the entire period. It would be inequitable to allow the petitioner, which had sat over the matter, to take advantage of his inaction in claiming misuse of charges. Here the petitioner was DDA. Even as to the contention raised on behalf of the petitioner that there was no limitation prescribed for making a demand of area charges, the division bench, relying on the decision of this court in State of Punjab versus so-and-so, observed that even where no period of limitation is indicated, the statutory authority is required to act within a reasonable time. In our view, what would constitute a reasonable time depends on the facts and circumstances of each case, but it would not be fair to the respondent if such demand is allowed to be raised after 25 years on account of the inaction of the petitioner. That statute really creates a Miller trustee. when law empowers somebody, my lord, that he is the trustee of the nation. And if you do not discharge your duty, by virtue of which your laches, or if I may use that expression, your permission, soft permission, yes, you carry on because this relates to Article 21, we feel. Suddenly, after 35 years, just in one stroke of night, you will remove them. Whether that's permissible. Now, but that again, my lord, brings us to the question of the basic principles of natural justice. Now, but as your lordship is well aware, I don't have to argue this on this point. In Escorts matter, the Supreme Court said this is not merely formality. This is also a substantial justice. Therefore, any action taken in violation of the principles of natural justice is void. But that is Escorts Farms, 2004. Again, first 1994 4 SCC 422. Now again 94 to the
Violation.
1994 4 SCC page.
page.
1994.
This is violation of the principles of natural justice.
Well, I don't think I have to cite authorities on this.
Number 4, double.
That this becomes a nullity.
422.
422. Now just
Which paragraph?
28.
paragraph I lead to paragraph 28. The others are discussing the other Supreme Court judgments. I am not really on that. The aforesaid, however, is not sufficient to demand setting aside of the dismissal order in this proceeding itself, because what has been stated in the ECIL case in this context would nonetheless apply. This is for the reason that violation of natural justice, which was dealt with in that case, also renders an order invalid, despite which the Constitution Bench did not concede the order of dismissal passed without furnishing copy of the inquiry officer's report would be enough to set aside the order. Instead, it directed the matter to be examined as set as so and so, so and so. As it, though there is some controversy, as has been noted in pages so and so, writ jurisdiction under the Constitution on the question as to whether a violation of natural justice makes an order void or voidable. It has been accepted by this court in paragraph 18 of Nawab Khan so and so. The only safe course until simple and sure light is set from the legislative source is to treat as void any order made without hearing the party affected if the injury is to a constitutionally guaranteed right in other cases also. Since natural justice has been regarded as a part of Article 14 by two constitution benches. And the same was followed with an Escorts matter. I am not really piling up the judgments. But the point was taken that I have given notice. Supreme Court said notice is not just. Natural is a substantial procedure. That is, my lord, 2004 4 SCC, page 281. Huh? No, I don't think I need to place it. এটা দিয়েছো দিয়েছো দর্শককে দিয়েছো Now, Lord, now again, Lord, I have to go back on the question of social justice and livelihood. 2011 7 SCC page 547. আমার বই দাও
SCC page.
page 547. Lord, paragraph 77. Sorry, not 77, Lord, paragraph 75 onwards. Yeah, Lordship, the facts might be known to your Lordship. It was a very controversial issue. In the name of countering, my lord, the so-called Naxalites, the government, my lord, built up a force called Salma Junoon without having proper qualification and training. In that background, Supreme Court is saying. Paragraph 20, Article 21 is violated because notwithstanding the claim volition on the part of these youngsters to appoint as SPOs engaged in counter-insurgency activities, youngsters with such low educational qualifications cannot be expected to understand the dangers that they are likely to face, the skills needed to face such dangers, and the requirements of the necessary judgment while discharging such responsibilities. Further, because of their low levels of educational achievements, they will also not be in a position to benefit from an appropriately designed training program that is commensurate with the kinds of duties, liabilities, disciplinary code, and dangers that they face to their lives and health. Consequently, appointing such youngsters as SPOs with duties that would involve any counter-insurgency activities against the Maoists, even if it were claimed that they have been put through rigorous training, would endanger their lives. But going from that angle, the Supreme Court says Article 21 comes in. The court has observed in Olga Tellis versus Bombay Municipal Corporation, life as observed by Justice Field in Mon versus Illians means something more than mere animal existence, and the inhibition against the deprivation of life extends to all those limits and faculties by which life is enjoyed. Certainly, then paragraph, within the ambit of all these limits and faculties by which life is enjoyed, also lies respect for dignity of a human being, irrespective of whether he or she is poor, illiterate, less educated, and less capable of exercising proper choice. State has been found to have the positive obligation, pursuant to Article 21, to necessarily undertake those steps that would enhance human dignity and enable the individual to lead a life of the same dignity. But I repeat, my lord, the state has the duty. You cannot just shift the rest of the individual. Why can't you grow yourself like a Mr. Pichai? Therefore, you have no right to life. No. Obligation is on the state. The preamble of our constitution affirms as the goal of our nation the promotion of human dignity. The actions of the state in appointing barely literate youngsters as SPOs engaged in counter-insurgency activities of any kind against the Maoists, who are incapable on account of low educational achievements of learning all the skills, knowledge, and analytical tools to perform such a role, and thereby endangering their lives, as necessarily a denigration of their dignity as human beings. You cannot simply say, I have given you appointment. You have accepted the appointment, keeping your eyes open. The court finds you are throwing them to dangerous zone without giving them the proper training, proper education, proper learning, proper judgment. This is violation of Article 21. It's your duty, not the obligation of unfortunate youngster. Then, but the last portions, I am not troubling my lord. Then state can kindly turn to paragraph 84. As we heard the instant matters, we were acutely aware of. Sorry, Mulad, I have skipped. Not 84. Let us come from 81. It is in the light of the above that we proceed to pass appropriate orders. However, there are few important matters that we necessarily have to address ourselves at this stage. The necessity arises on account of the fact that the state of Chhattisgarh and the Union of India claim that employing such youngsters as SPOs engaged in counter-insurgency activities is vital, and necessary to provide security to the people affected by Maoist violence and to fight the threat of Maoist extremism. This is the justification by the government. Indeed, we recognize that the state faces many serious problems on account of Maoist violence, notwithstanding the fact that there may be social and economic circumstances and certain policies followed by the state itself leading to emergence of extremist violence, we cannot condone it. The attempt to overthrow the state itself and kill its agents and perpetuate necessarily has the obligation, moral and constitutional, to combat such extremism and provide security to the people of the country. This, as we explained, is a primordial necessity. When the judiciary strikes down the state policies designed to combat terrorism and extremism, we do not seek to interfere in security considerations for which the expertise and responsibility lie with the executive, directed and controlled by the legislature. The judiciary intervenes in such matters in order to safeguard constitutional values and goals. My lord will not, they might take this argument, my lord, I'm just apprehending. The state duty, state has done what the court would do. Court is not mere spectator. Repeatedly Supreme Court saying, when it comes to the question of Article 21 and Article 14, these are two primordial considerations of the Constitution. Then paragraph 83, where the Constitution judgment is quoted. I am not reading that. Paragraph 84. As we heard the instant matters, we are acutely aware of the need to work on the razor's edge. In arriving at the conclusion we were guided by the facts and constitutional values. Now, this is my humble appeal before the Constitutional Court. Please be guided by the constitutional values. Might be you are working on razor's edge, the Supreme Court says. Still, we have to protect and uphold the principles of Article 21. Well, I am not.
87.
Hmm?
87.
This is the duty of the court, not which I am placing. I am not troubling my lord with any other paragraphs. Then, my lord, again, specifically when the court holds and discusses, my lord, the principles of right to life.
Continuous madam আসতে কথা
দু হাজার 2016
Position 2016.
So this is on the question of the right to life, Article 21.
Right to life.
2016, 2
Which paragraph?
Now I am placing from paragraph
33.
24.
34. Para 20% or 34?
Also 24 to দরকার নেই, দরকার নেই। Before legislature come to paragraph 28. Statute does not prescribe the time limit for exercise of revisional power. It must be exercised within a reasonable time frame. In the instant case, it is evident that the constant litigation has been carried on by the appellant and therefore they cannot be accused of suddenly waking up after 13 years to claim their land. Further, in the context of limitation, it has been held by this court in a category of decision that when what is at stake is justice, then a technical or pedantic approach should not be adopted by the courts to do justice when there is a miscarriage of justice caused to a public litigant. Here, my lord, the same principle I would appeal to your lordship, my lord, to apply so that these people can survive. Now, these are the basic principles. It's no good of my lord piling up with judgments. Therefore, we are, my lord, they are not just of our, my lord, whims. We are there to protect our livelihood. My lord, there are three types of cases before lordship. I'm concluding, my lord. One is the slum dwellers. But I don't know whether lordship had the experience of having a journey in suburban trains during your younger days. You must have seen the situation. Lord, again, Lord, is quite embarrassing, but we have also faced a similar situation when this Honorable High Court directed that within 48 hours, the slum dwellers around the Lake Gardens railway track should be removed. Situation was such. The police said that if we have to carry out the order of the High Court, there might be few killings. They will throw pale stones. We have to counter with fire. And sir, definitely it's a case of mass killing. I don't know how the court will tackle it. They approached me so that I can move the court. And I was holding a different chair. I did not. I talked to the Chief Minister. Within half an hour, but they were given replacement, shelter. That the shelter is more important. Give them the shelter and then proceed. They want to, Lord, evict us from this, what should I say, jhoparis and shelters. I don't know whether you have the experience. Anyway. And then the hawkers who are on the pavements along the precincts of the railway station. And few.
With regard to the hawker, Mr. Bhattacharya, there is a statute.
No, that is street hawkers. Milord,
Yes.
street hawkers, Milord, where that act, Milord, that's a pointing act, Milord, specifically leaves the railway, Milord, out of the statute. Let's say that act would not apply to the railways.
Railways.
If I am not really, Milord, arguing on street vendors, that is the matter of the municipal corporations that they will look into it. But here, the railway, Milord, is not only doing these atrocities, Milord, to the platform vendors. They are doing it, Milord, even to the persons, Milord, who are allegedly, according to them, in the precincts of the railways. On the roads. Cannot be.
On the roads, meaning thereby within the railway property.
Milord, that question would further arise. Milord, platform I can appreciate. The railway would definitely, Milord, have the authority over the platforms. I am not going to argue, Milord, which is not. But
Beyond the platform, also railways have some lands.
no, Milord, outside the platform station.
No, maybe outside the platform, but they have a boundary. It's not that just after the platform, the railway property ends. It generally extends to something beyond the platform.
Milord, first of all, Milord, assuming, Milord, my Lord's point of view, I say even then you cannot do this. Well, keeping aside, Milord, the issue of that, whether the land belongs to railway or the municipal authorities, the government authorities. But the people who have been doing the livelihood for years together. That one lady of 80 years was weeping. I have none to see me. সকালে আসতাম 10 টাকা বিক্রি হতো. I can speak.
Only one thing, Mr. Bhattacharya, you are acquainted with the facts of these matters. I do not know whether any of these matters, because in some cases the railways allot certain stalls by way of license and other arrangement.
Agreement.
So, in any of this, in any of these cases, whether those are involved,
Yes.
in which matter?
But I will.
I shall.
I asked you to do it beforehand so that we can.
মুখে মুখে বললে হবে নাকি?
No, those were which
So
matter
having
your licenses are still valid.
No, actually not. Actually not. In some cases, Milord, licenses are valid. In some cases, when licenses were not renewed.
Only, so this is one part. And what is your argument? What should be, if at all, eviction is to be carried out? What should be the mode? What procedure should be followed?
Milord, first of all, Milord, they have to show before your lordship that there were complaints from the passengers. That's the ground taken. That the passengers are feeling inconvenient. That's the ground. Now, Milord, that they have to first of all satisfy your lordship. They have not filed affidavit in spite of direction by the court. And if that is so, then you have to maintain a balance. I would again submit, Milord. You may say that 3/4 of the platform area should be completely vacant for the passengers. No one be there. Yeah, do it. Maintain the balance. Competing fundamental rights. What is the duty? Duty is to maintain the balance so that the both rights can be enjoyed. But more important is, which is the greater public interest. Therefore, if you want to remove, very well, I want to have a better project, give them time, give them sufficient accommodation saying that you can do your business to that place we are providing you. Because it relates to, again, I say, fundamental right of Article 21. Where do we go? Do we go on the street, with a begging bowl?
Anything more?
I am becoming emotional. I don't want like
anything more?
Direction.
No, these are the basic things. Milord,
এই থিমটা নিয়ে যেটা আপনি বললেন
there was one thing in Milord Bracebridge matter. Your lordship kindly see the order which was passed. There, Milord, I had cited the one Supreme Court judgment. Supreme Court said that the railway, government, everybody will.
What happened to that matter?
In one matter, Milord,
Because that was an interim order.
interim order. That's it.
So what
Nothing. No substantial progress. No substantial progress. In one matter, your lordship, Milord, remanded us back to the authorities for a hearing. Just now, I am told they have passed an order. They're sticking to their old point. I have asked them to challenge it fresh.
আচ্ছা এইটা দেখাবেন
Mr. Bhattacharya?
These are the fundamental things.
Yes.
Paragraph 40.
Commissioners, you want to add anything?
অর্ডার রেকর্ড করা আছে।
Look, may I take leave?
Thank you, Mr. Bhattacharya. Yes.
Item number 8.
Of matters which are with regard to railway eviction. Will it be my lord's pleasure to direct the petitioners to segregate those matters, because the question fell from my lord that some are licensees. There are 4 sides of matters. One, the people who are occupying the railway platforms. Others are who are occupying the adjacent lands which belong to the railways. Some set of matters are where they are claiming right either as owners or as tenants under some other third party, be it state, be it court trust, whatever it is. And fourth are those people who are saying, lordship, that they are under leave and license or some type of, there was no forceful entry or illegal entry at one time.
Initial entry was permissive.
So therefore, my submissions, whatever my learned senior friend has submitted, is on fundamental rights. I will submit on fundamental duties, that whether a trespasser has a right to stay. Then another segregation of matters are who are commercial activities are being carried on. There is a larger bench, 5-judge bench of the Honorable Supreme Court, which said that it does not come within Article 21. Malo, that's my submission. Then I will submit those matters where they are rank trespassers. There will be one set of submissions from me. Those matters where they have some semblance of legality at one point of time. There I'll have different set of submissions. And lordship platform, I have there what comes, Milord, what again was being submitted by my learned senior friend, that which passenger has come and reported. Then there are people who are staying adjacent to the railway tracks. Tomorrow anything happens, no passenger will come. They will come. There will be a hue and cry, people die. And there are sections in Railway Act that people, and I have fought those cases where people who are not even traveling with a valid train ticket, anything happens, a claim is on the railways. So, Millard, there is ample and voluminous submissions to be made, Millard.
That is why I asked Mr. Ahmed to
So, Millard, that
categorize. They
segregation
have not
is
done
required.
this.
Because I cannot make a blanket submission on everything where everybody will. Article 21, Lordship, with deepest of respect, is not a panacea. Now it has become a panacea.
Let I will hear you. sir.
Lordship, on a
Well, I am only on that segregation.
My
lord, only one-
factual aspect, because our case, as my learned friend was saying, there is some amount of legitimacy in our case. We were original refugees from 1947. We were allotted lands. We were paying fees, and after a certain time, railways did not accept. We are 1 kilometer away from the station. There is a private land in between, which I can demonstrate with pictures. I was expecting my learned friend to file his opposition so that I could satisfy your lordship that we do not come under any of these categories where we should be able to.
All right, let me hear of the.
yes.
My lord, only one thing,
thereafter I
item
will
80
consider legal facts.
Item 84, your lordship need not to open the brief. Only two things. Tomorrow has been date fixed for demolition. My lord, our shops are, my lord, outside the platform, allegedly on the railway track. And my lord, WBSCDCL today, during course of this matter was going on, has issued a notice for disconnection. These are the only things. Otherwise, everything is safe.
Malad, kindly turn page number 108,
Item number
85.
85 have filed it.
84.
Mine was item 66.
Well, item number 84.
Yes.
Malad, kindly turn page number 108. 107.
107.
Yes. Mustafa Mistri is the one of the petitioner.
107. Yes.
Petitioner number 1, my lord. He got the permission in the year 1995. My lord, got the date above, my lord, in the corner.
Mr. Trivedi, you are appearing in 85.
Lordship, that is what I am saying, Millard. I will request the Ministry of Law, Millard, that though it has been allotted to various.
85, who is appearing?
No.
You don't know.
I gave the copy as a ministry as well as the
Petitioner or many petitioners?
40 petitioner, because they 40 petitioners, my lord, they are same from Baruipur railway station, my lord.
No, this document you are showing page
For the
107.
petitioner number 1, my lord, I am just showing it, and thereafter, my lord, I am
But
showing
these
the
writ petitioners have been allotted.
no.
Why have you clubbed them, joined them?
My lord, because of the notice is the singular notice is there, even an undated, unmemo notice.
All of these petitioners do not stand on the same footing. How much court fees you have paid?
My lord, I will pay because, my lord, I will pay by today, my lord, because yesterday I will give the because of that dint of that notice. Tomorrow,
Maybe
the
the
verbally says,
But all of these petitioners do not stand on the same footing.
yes, but they gave the notice in the same manner, threat given the same manner to
Maybe
all
the
the.
reliefs may be different. Why have you clubbed them?
No. Now they are in the same footing. I place my case, my lord, thereafter. My lord.
Yes, place your case.
Yes, my lord. So what happened, my lord? Page number 107. Thereafter, page number 108. Permission was given, and thereafter, my lord, page number.
No one is
114.
appearing. No one is appearing. Do you have an extra copy of this petition?
Yes, I already gave.
Your lordship, I have informed the railway authority.
I gave.
You have a copy of this?
Yes, I
petition?
gave.
Given the scanned copy.
Scan copy you have? Yes.
So thereafter, my lord, for the time being, we gave the fees. Thereafter, railway, my lord, stopped to collect the fees, my lord, because we gave this fees, my lord, page number 114 onwards. 114. This is the license fees, we gave it. Thereafter, railway stopped to get it that fees, my lord, but we occupied that place since 1995, my lord. So more than 30 years we are in that
All
place.
these documents are of Mustafa Mistri.
Yes, my
No
lord.
other petitioners have any other
No,
document.
no. I not get it.
You
I
want
not
to
get it.
segregate him
So,
from
my lord,
others, or you want to move it jointly?
so my lord,
Choice is yours.
page number 87.
So, I'm asking you, do you want to move a joint writ petition or you want to segregate it?
My lord, jointly, it is the joint cause of action. Why? Why, my lord, why I place it, my lord.
This do not
After,
no documents of others have been disclosed, I'm telling you.
yes, my lord.
I'm putting you on notice on that.
My lord, kindly turn page number 87.
Yes.
Topon Banerjee, another person.
How many, which of the petitioners have documents have been
I-
allotted plots
My lord,
by the
because
railway?
of that,
Please
my
specify.
lord.
Which of the
After some time, the railway stopped collecting this
I'm
renewal
asking
fee.
you, which of the petitioners
Two
were
of the petitioners have that.
only two?
Yes, my lord.
Which
Page
petitioner
number
one and-
87 and page number 130.
No, petitioner number 1 and which petitioner?
30.
30.
Yes.
So with regard to the others, you do not have any documents.
My lord, still I have not. But the fact is that may place the fact, my lord. Why? Because we clubbed it. After some time, the railway stopped collecting their fees, my lord. Thereafter, we occupying that place. Since so from that document, it is evident we occupying that place since 1995. But railway not take any action. So all of the sudden, they came with an undated, unmemo. There is no such memo number. Who issued it in page number 117? It is annexed.
Mr. Trivedi, in this matter with regard to petitioner number 1 and 30, that is the submission of the learned advocate for the petitioner, they were allotted some space or some stalls. So initial entry was permissive. Thereafter, nothing was collected. So subsequently, they became, according to you, unauthorized occupant. But initial entry was permissive. With regard to 1 and 30, not with regard to the others.
Others,
Please
okay.
take instructions on this.
That's my on factual aspect. That's
Yes.
My lord, as far as my lord is saying,
Okay, only go ahead. ये करें ना?
Lordship, as far as I understand from his submission, it is still being downloaded. My lord, what I understand that what has fallen from your lordship, that two of the petitioners have certain valid document which have some semblance. And
Valid
that
or invalid, I do not disclose such
there is some
documents
semblance of
issued by
semblance
these.
of validity. I'm just putting it rightly, reframing my that. Semblance of validity is there. And we are there. So, Lordship, as far as other petitioners are concerned, Lordship, they may not be, my lord, protected.
That is
ones.
why I have asked you to take note of that, take instructions with regard to that, because what should be the method that is to be considered interstate the petitioners.
Yes, ma'am.
Yes. So the other persons stand on the same footing as Mr.
Yes,
Bhattacharya.
yes. Even that person also, because they're not collecting the fees, but we are occupying that same place since 1995. That's my case, because they not take any adverse action against me since 1999.
Any other thing?
No,
you want to
my lord,
point
no,
out?
and not.
Yes.